If someone you love just passed away in Texas and left behind a house, you're probably overwhelmed right now. You're grieving, and on top of that, people are telling you about this probate, executor, court filings, and you have no idea where to start. I've helped dozens of families navigate this exact situation, and I'm going to walk you through 7 things every heirs in Texas needs to know. Stick around because number 3 is a shortcut that could save you months in probate process, which can be thousands or tens of thousands of dollars in holding costs and attorney fees. My name is William Zhang. I am a probate real estate consultant and the founder of TexasProbateProcess.com. I work with families across Texas who are dealing with inherited properties, whether that means figuring out how to sell, what the timeline looks like, or just understanding what comes next. So let's get into it. Here's how probate works in Texas and the 7 things every heir needs to know. What probate actually is here in Texas, it's basically a process for the court to supervise the process of you handling all of the assets and make sure the assets are going to the rightful heirs. In Texas, this usually happens in the probate court of the county of the deceased. It applies to real estate, personal bank accounts, vehicles, sometimes your baseball card collections, or just any assets that the deceased had. Anything that's under the deceased names. And also, this also includes the liabilities, the debt, and things like that, right? So why this matters to you is that if there's no proper probate process, you cannot legally sell the house, refinance the house, or transfer the property, or handle any of the affairs, even if your name is in the will. So here is a quick overview of the probate process. This is a very simplified version. Step 1, we validate the will of the deceased. Second, we'd appoint an executor. Executor is like the project manager, the CEO of this whole process. And then step number 3 is to pay off the debts and taxes. And step number 4, you distribute the assets to the rightful heir. It has to happen in order, and the court controls the pace. They have to go through and approve of it. But there are some ways to streamline and skip through it if you meet certain criteria, which I'll talk about later in this video. So don't skip that. So be sure to stick around for that point. Let's go over the step number 1, which is validating the will. If there's a will that exists, the court confirms that it's legally valid here in Texas, meaning it's properly signed, has witnesses, and is not contested, right? And so that's like a much straightforward process. And that's in a more ideal situation. But if there is no will, the court has to conduct this process called determination of heirship. It's a legal process that identifies who the rightful heirs are under the Texas law. And as you can imagine, that process can be more complicated than just having an existing will. So that can add a little bit complication into the whole process. So there are some common themes that with the existing heirs, even if everyone in the family agrees to who gets what, the court still has to formally validate it. It sounds a little unfair, sounds a little surprising, but it's the process that's in place right now. Okay. Then number 2 is to appoint an executor. The executor is, I like to say, executor is like the CEO, it's like the captain, it's like the project manager of the whole process. They're the one managing the estate. They pay the bills, for example, mortgages or credit card bills, any existing credit card bills of the deceased, file the paperwork, communicates with the court, and ultimately distribute the assets to the rightful heirs. And usually they are part of the will, so they're named in the will, so they're incentivized to go through the process and do a really good job of that process, right? If there's no will, there is a situation if the deceased did not have a will in place, maybe it's an unexpected early death or some strange situation, the court can decide for you. Texas law has a priority order. The surviving spouse comes first and then the next of kin. Sometimes that can cause some disagreement between family members. Step number 3, quick overview, is that you pay the debts and the taxes. The debts come first. Before the heirs, the people receive anything, the estates must settle all outstanding debts, including things like medical bills, car bills, credit cards, liens, and taxes, right? Everybody got to pay taxes. And then the creditor notice period. Texas requires a minimum 30-day window where creditors can file claims against the estate. 30 days is the minimum window, but usually it's going to be about 2 to 3 months, sometimes even 4 months before this thing is processed. is handled. So this means for the property, if the estate doesn't have enough cash to pay the debt, the executor may need to sell the house to cover them. And that process can happen at the same time. Okay. So number 4, very fast, is to distribute the process. This is the process that everybody loves. The probate process is completed. Now every debt is paid off. All the remaining assets, including house, which usually is the most valuable part. But sometimes, some people might have some valuable baseball card collections or Pokemon cards collections, which is not uncommon nowadays. We're talking about real estate here, are distributed according to the will. Now, the estate inventory has to file with the court. The executor, as the captain, as the project manager, you have to file a detailed list of every asset and their fair market value to the court, right? So for example, how do we know how much this house is? That's why you reach out to someone like me, a professional real estate consultant, to help you get an idea of the fair market value of the house, so that when we're making decisions, we know how much inventory, how much assets we have, how much liability we have, and make a proper decision, right? And then if you need help finding the right probate attorney or the right probate real estate consultant in your area, you can use the link down below, and happy to connect you with the right people in your area. And this is when you can sell. This is when you can sell everything and then distribute the assets. So this is the part where everybody just gets a relief from the whole process is finished. Now, here is a key distinction. There are some people in their head, they will think, my mom said the house belonged to me. He left the house to me, so it's mine, right? Legally, no, not yet at least. Until the probate transfers the title, you cannot sell the house, refinance, or do anything with the property, even though in theory, the house can be yours, right? So this is the most common misconception a lot of clients have. They think that it's just a straightforward process like that, but sometimes, but often than not, it's not. That's why it's good to have some prepare ahead of time. Many families lose months because they assume they could just start using or selling the house right away. So they put this off. So that's why if you're going through the probate process, someone in your family deceased or passed away, when you're ready, you should reach out to a professional. You can use the link down below here at texasprobateprocess.com. We'll connect you with the right professional. How long does the probate process take? So the week number 1 after the death happened, usually is that you file the probate application and submit to the county court where the deceased lived. Then it's the court hearing, which happens 2 to 4 weeks, within 2 to 4 weeks. And then appoint an executor, appoint the person who's going to be in charge of the whole probate process. The judge is the one who grants authority to mandate the process. And then the month 2 to 3 creditor notice period, usually it's minimum 30 days, but usually it's a little longer than that, about 2 to 4 months, more likely than not. That's the mandatory window for the creditor to file claims. And then months later, that's when you can settle debt and file inventory and document all the assets for the court. And then finally, the assets, all the house, the sale from the house can be distributed, including selling of the real estate if needed, right? So if it's a straightforward process, 4 to 6 months is pretty typical here in Texas. That's how long a probate process takes. But if it's a contested or distributed or missing documents, multiple properties, that's more complicated. It can take 12 months to 24 months. That's a long processing time, right? If you want to know the Texas probate process, here is a free 90-day checklist that you can download using a link down below. It goes over the deadline that people miss that can catch them off guard. You can compare whether you want to do this DIY or versus attorney, and which step really needs a lawyer, and the cost worksheet that calculates your monthly holding cost of the house, because the house still accumulate costs as we speak, which we will talk about later in this video. You can download for free using the link down below. And as I mentioned before, you ever need help with the whole probate process, finding an attorney, finding a real estate consultant, understanding the whole process, you can learn more using the link down below at texasprobateprocess.com. And number 3, this is a shortcut that I mentioned at the beginning of the video. This is how you can streamline everything and skip all of this waiting. And that is the Muniment of Title. That is basically a hack to this whole process, and you have to qualify for this situation. What happens is that this only takes 6 weeks to complete instead of 4 to 6 months on average, right? And only has 1 court hearing needed, but you have to qualify. You have to make sure it fits your situation. It's basically skipping appointing an executor. The Muniment of Title is a single hearing where the judge gives you the right and say this will is valid, and the property transfers to the heir. Done. And that's a very straightforward process. And here's a quick comparison. If you go through the full probate process, you have to assign an executor, you have to notice the creditor, 30 days minimum, usually 2 to 4 months. You have to go through all the court appointments, supervision. Sometimes you have to get permission to do every single step. That's a headache, right? That's a painful process, 4 to 6 months minimum, and it has legal fee. Higher legal fee, usually about $3,000 to $7,000. It really depends on how complex, how complicated the case is. But if you have a Muniment of Title, you don't need an executor. You have no creditor notice period. It's only a single court hearing, and it takes 6 to 8 weeks, and it's much lower cost because it's a straightforward process. And how do we qualify for that, right? How do we get Muniment of Title? These are the requirements to get that process. One, you have to make sure you have a valid will, meaning that the deceased left a signed, properly witnessed will and qualify here in the state of Texas. And two, there are no unpaid debt other than the mortgage on the property itself. So there's no outstanding medical bills or outstanding credit card bills or outstanding lien against the property or anything like that other than just the mortgage itself. It will not work if you don't have a will and there are unpaid debts like credit card bills or medical bills or tax liens or even sometimes if you forgot to pay the contractor for the work done on the house, right? So if you meet the first two conditions and you can qualify for the Muniment Title, that is a speedy way to make sure this whole process works without spending tons of money, without incurring tons of holding costs. So that is one question you need to ask to the probate attorney during your appointment. Do we qualify for Muniment Title? This could save you 3 to 4 months and thousands of dollars in fees. And here's point number 4, the tip number 4 that you should know as a Texas heir inheriting property and going through the probate process is this process called independent administration. This is the most common type of process here in Texas, and it's the easiest for selling property other than the previous one. The executor can sell without court approval. What it means is that you don't need to go to the judge and sign off on every single offer that you receive, on every single step that you're taking. And this is saves you tons of headache, tons of back and forth. And as a real estate consultant, sometimes I'm helping buyers putting an offer on a house that is going through the probate process. They are a dependent administration, which I'll talk about next. And that process is painful because they have to get approval on every single offer, every single price adjustment, every single process. And it's a longer turnaround. Usually it pushes away buyers in the process, and it's very painful. But so having an independent administration speeds things up. It's a big deal for heirs because in some states, every real estate transaction during probate needs the judge approval. But in Texas, this is one good thing about Texas is that independent administration makes this much smoother. So here's the other case, the dependent administration and probate close. In the dependent administration, it requires court approval for every single transaction. It's less common, but it happens when there are no will or there are disputes between heirs. And it's slower and more expensive. You incur more holding costs because the whole process takes longer. You're paying the property taxes, you're paying the maintenance costs, the insurance. You're also paying the legal fee if they charge you by the hour. So you accumulate all of that as we talk. And the probate already closed, meaning that the heir owns the property outright. So it can sell freely like any other property with no restriction. Just so the whole big point, the whole big takeaway about what we talked about to this point is that don't assume that you have to wait to sell your property. Many families let the property sit for 6 to 8 months thinking they can't do anything, but it's costing them money every single month. So here's a typical case of what holding costs will look like here in Texas. As we all know, Texas real estate property taxes are pretty high, one of the highest in the entire nation. And even a vacant property doesn't matter. It will still incur property taxes. Monthly, usually about $300 to $800 a month, sometimes even higher if the home is more valuable, has a higher assessment value, right? And homeowner insurance, you have to make sure you have homeowner insurance. And usually it's about $150 per month to $400 per month. And then HOA dues, that's still incurring every single month, every single week. And then you have to make sure you keep the lights on or the water is running, right? You don't want to just turn them off all of a sudden. And then you have to somehow maintain the cost, make sure it looks somewhat livable. Now, obviously, this fee is optional. And sometimes if the house still has mortgage on it, you have to keep on paying the mortgage. Someone has to keep on paying the mortgage, right? So this assume if you own the house outright, here's still some of the costs that you have to cover. So the estimated monthly cost is about $625 to $1,900 and more if there's still mortgage on the house. So definitely consider going through this process to understand whether you can sell this house fast and early so that you don't have to incur those costs. And here's a quick warning. Here's a quick tip about the insurance vacancy clause. Most homeowner policies void your coverage after 30 to 60 days if the home is being unoccupied. So that means that if a break-in happens or a burst pipe happens, these things will not cover. So if that's been sitting empty for 2 months or something happens, you're paying out of pocket. That's definitely something to consider about what to do in the process. All right, thing number 5 that's very important is that what waiting 8 months will do or cost you as a family. The most simple, straightforward situation, as we mentioned before, is that there's a clear will. There's only one property, and we have siblings who get along well. There's no disputes, right, about who gets what to do with the property in the process, right? But if you wait 8 months to start the whole process, the property tax might went delinquent, the insurance might have lapsed, you might be incurring more additional costs that you could have avoided have you started this process earlier. And then something happens to the house get flooded, or something happened to the roof, or somewhere get flooded. Some people broke into the house. That's a lot of money in damages. And if it's completely uninsured because the vacancy clause, if someone has to carry that cost, and if you want to sell it down the road, they'll lower the property value, or that you have to fix it up before you can go into the market. So the lesson is that every month you wait is money coming out of the estate, which means it's out of your pocket as an heir. If you want to know the holding costs, if you want to understand what the week by week action should be, you should download the free resource using the link down below. And then here are some common things that you need to know as well as the heir. Thing number 6 is the title issue. Title is a big deal here in Texas. I'm sure it's a big deal everywhere. But sometimes there are some unknown heirs that might have a legal claim to the home. Might be dads, family across the town or across the state or across the world somehow learned about the situation and now popped out of nowhere and wanted a claim on the property. It's not uncommon. Sometimes it does happen. Happens more often than you think. Any of these can really surface during the whole selling process and the legal heir no one expected. And when that gets discovered during the home buying process for the buyer, because they will find it, and that happens at closing, everything stops and it just wasted everyone's time and resources and money to go through that whole process. And the deal may die completely. The way to avoid that is to make sure you run a title search beforehand. We're going to talk about that later. But right now is that there are some old liens. There's another situation is the title issues number 2. That's very common is that the old liens, they're debt attached to the property from years or even decades ago. For something like a vendor's lien, for example, a contractor, let's say a solar panel installer had a lien on the property. And maybe someone did the fence or repaved the pavements, or but then the bill wasn't clear, so they file a contractor claim on it. There are some property tax lien issues, IRS tax lien issues, or judgment liens from the lawsuit. So all of these can surface during the selling process, and you're just not aware of it, which is very common. So it matters because the lien follows the property. It doesn't go away just because mom or dad or uncle or auntie passed away, or grandpa, granddad. Even though the debt wasn't yours, it's now attached to the house that you inherited. So you got to take care of that before you can sell the property. Another thing that's very common is the missing documents. The deed is not properly recorded, missing affidavits or incomplete probate filings from prior generation. For example, grandma passed the house to mom. Mom passed away, passed the house to you. But then the grandma's probate process was never fully completed 20 years ago. Now you're trying to sell, and the title chain is now broken. And the way to fix it or to prevent that from happening is to run a title search before listing the home, so that you know what you're dealing with, what you will deal with, because nothing escapes this. People will find out, whether it's during the title search process from the buyer
or eventually before closing, this will be discovered. So it's better to go through that process beforehand and understand what you're dealing with. That's why having an attorney in place and real estate consultant in place can really coordinate this from day one, not at the closing table. And if you need help, mentioned before, use the link down below, access texasprobateprocess.com to access all the free resources and educations that we had about this process. So the title issues that crow probate deals in the summary: unknown heirs, very common. And then old liens, more common. And then missing documents. And then the one way to prevent all of this is do a title search before listing the property. Find the issues early so we can fix it before we kill the deal. And the final thing, the last thing you need to know is that you don't need to figure this out alone, right? It can be a very complicated process here in Texas. That's why having an experienced real estate consultant, having a real estate consultant that can help you coordinate, find you the right estate attorney, the probate attorney, that can give you introductions to the right people and help you understand and value the property accurately and make sure that we can market it to the right people. Sometimes you want to list the house for sale on the market so we can get more value, more full value from it. Sometimes you want a quick closing, a cash closing, and you want to introduction to a list of investors in the area so you can get the cash early and not avoid the holding costs. And you want to make sure you meet all your court deadline. That's why working with a probate consultant can really help you with this whole process. So that's why if you ever need help with probate property in Texas or understand the probate process, we help families navigate that every single step, finding an attorney to selling the home. You can access the free guides, free resources. You can get help using the link down below. You can access everything at texasprobateprocess.com and subscribe to the channel. Thank you for watching, and we'll provide new guides, new process, new education every single week. Thanks for watching.